All right, ladies and gentlemen, we are going to bring this special meeting of the Leon County Board of County Commissioners to adjournment. We're going to start with a Pledge of Allegiance. Mr. Administrator, please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Thank you, Commissioners, for your willingness to come to this special meeting. I appreciate your flexibility in that regard. We are obviously under some time constraints with this item, and so that's what justified the calling of the meeting. So with that being said, we just have one item. I imagine we'll have some discussion about that, but I'm going to turn it over to the County Administrator and the County Attorney to get into the details of what we are going to be discussing. Thank you.
Thank you, Mr. Chairman. Commissioners, again, let me echo the Chairman's thanks to you for your availability for attending this special meeting today on fire rescue services assessments and fees. The Chairman called this special meeting to provide the board with an important update and to seek the board's direction on the dispute resolution process with the city regarding the city's request to increase the fire services rates. Commissioners, as you recall, and as directed by the board, the county initiated the dispute resolution process with the city. In a moment, Chastity will bring the board up to speed on where we stand, and we will be seeking some timely direction needed for the county to proceed. I want to first provide just a quick refresher on the last 7 months, Commissioners, leading up to this meeting. As you know, earlier this year, on January 14th, the city informed us that the current 5-year fire services fee and existing reserve for fire services were insufficient to support the remaining 3 years of the 5-year term. We were only 15 months, Commissioners, into the 5-year term when the city identified both cost increases for items that were contemplated in the development of the 5-year fee, as well as new costs, which were not contemplated in the development of the 5-year fee. The city's position was then and remains that these new costs and cost increases necessitate a 22% increase for all property categories effective October 1st, 2025. As you'll remember, Commissioners, after learning of this, both the county attorney and myself informed Commissioners, and we met with our city counterparts to ensure that we went through the proper processes and procedures in relation to the interlocal agreement for fire services. While the interlocal agreement provides several processes for the county administrator and the city manager to address modest fluctuations in revenues and or expenditures during the current 5-year term, the Fire Services Reserve Fund, again, was insufficient to support the millions of dollars of additional costs identified by the city. Again, I know the board's well aware of that, but bringing you back up to speed. Since that time, again, we've followed that process set forward in our interlocal agreement, including the board on May 27th, making a good faith compromise offer to the city. Again, that's contemplated in our interlocal agreement. If we get to a position like this, that the aggrieved party, which was the county, would offer the city, again, an offer to a good faith compromise offer that would have resulted in a smaller fee increase and would have avoided a lengthy dispute resolution process provided in the interlocal agreement. However, Commissioners, at the budget workshop on June 11th of the City Commission, the city rejected the county's good faith compromise and voted to increase the rates at the full amount initially requested by the city. Once the city rejected the county's good faith compromise, staff initiated, based on the board's previous direction, the dispute resolution process provided in the interlocal agreement as directed by the board on May 27th. In just a moment, Commissioners, Chastity will explain the dispute resolution process, which quickly moved to the seating of an arbitration panel, which the county attorney's office has determined does not have the authority to compel the board to increase rates. That's very important. Chastity will talk about that in just a moment. I need to say, Commissioners, at the outset here, and just wrapping up sort of the recap of all this, that our county attorney has done an exceptional job. She'll go in with more detail on the arbitration process and the agenda item before you today, including the 3 recommendations related to the dispute resolution process and the issuance of first-class mail notices for the board to establish the FY26 fire services rates next month, again, at the current rate. That being said, Commissioners, I know it's not lost on any commissioner that this is a critical provision of service to our community. The fire services fee and assessment model, while not perfect, is exceptionally robust and technical in setting fair rates across all properties. We were hopeful that we would have been able to resolve this matter before getting to this point, Commissioners, and we remain hopeful in working with our city counterparts into the future, but in a way that reflects both the spirit and the letter of our current agreement. And we're happy to answer any questions you might have, receive the direction that you have for us today. And with that, I'm going to hand it off to Chastity Osteen. Chastity. Go ahead.
Thank you, Mr. Chairman. Thank you, Vince. So after the board's direction and the subsequent rejection by the city, in communication with the city attorney after initiating the dispute resolution process, both parties agreed to accelerate the dispute resolution process, mainly because there was a feeling that the rates needed to increase in the new fiscal year, but we use the uniform method to collect those rates. And we have a deadline to send in the tax roll and also to adopt any potential rate increase. So moved very, very quickly. I will say the city attorney's office was very helpful in doing so. We did retain an arbitration panel, and we started digging into documents and requesting answers and preparing for an arbitration hearing in early September. In the course of researching things, we also looked at the issue of rate increases and have made a determination that for 2 reasons, no arbitration panel could compel the city or the county to increase rates in any given amount for 2 reasons in this specific instance. One, whether to adopt rates, then if so, in what amount, as long as it's done legally, is a purely legislative function. And a court cannot make, an arbitration panel cannot make that policy judgment for a legislative body, such as the City Commission or the Board of County Commissioners. The other thing is, our agreement with the city is very, very clear that both parties have to agree to a rate increase. And no judge and no arbitration panel can amend or modify the express term of an agreement, which is basically what an arbitration panel would be doing if it were to try to compel the parties to increase rates, and if so, try to dictate an amount. That is the county's position. We feel very comfortable and confident in that position. The county has not publicly, or the city has not stated publicly it agrees with that position, but given that that is our position, we want authority from the board, and that's what option 1 would do, to basically rescind that issue from any potential arbitration that might occur. There's no need to. I mean, if our sense is they can't give us any relief anyway, it would be an unnecessary cost and expense to proceed with that. So staff would recommend that the board authorize staff to rescind that issue from any potential arbitration proceeding. So that's a time-sensitive issue, because right now we do have an arbitration hearing on the books, okay? 2, the notice, the first-class notice that we have to provide to constituents to let them know of any potential rate increase in advance of our September 15th meeting, public hearing. Previous direction from the board was to include an amount to contemplate a potential increase in those notices. But if our position is we don't have to increase rates, and the board's position is it's not going to, we need to know that that is the language that you want in the first-class notices that are going to be mailed out next week. So that's option 2, is to direct staff to only notice people who will receive or potentially receive a tax bill for the assessment for the first time, okay? So we would not be mailing any first-class notices under option 2, contemplating any potential rate increase, okay, to any constituents in the unincorporated area. So that's option 2. Option 3 is policy call by the board, of course. In the course of preparing for arbitration and digging into these issues, we've identified, based on documentation and communications with the city, areas where we believe that the city expended money without authorization in violation of the interlocal agreement, and also underfunded by undercollecting, as it was required to do under the interlocal agreement. We've identified 3 specific instances of that. We did ask 2 of them, we can validate today. The other one, we have asked for confirmation from the city, whether in fact they trued up, if you will, and they have not responded or provided any documentation to date. So option 3, if it's the board direction, would direct staff to retain a financial consultant and move forward to further investigate those. If so, and if necessary, to initiate the dispute resolution process to address any of those issues, which could at some point ultimately include and result in binding arbitration. I'm happy to answer any questions the board might have, but that is staff recommendation is options 1, 2, and 3.
Thank you, Madam Attorney. All right, Commissioners, Commissioner Maddox, Commissioner Minor, and Commissioner O'Keefe are in the queue in that order. We will start the discussion with Commissioner Maddox.
Are you speakers, Mr. Chair?
Oh, I'm sorry. Oh, Mr. Administrator, do we have any speakers on the item? Sorry.
Thank you for that, Mr. Chairman. We have 1 speaker, Stanley Sims.
Mr. Sims, name and address for the record, please.
My name is Stanley Sims. I'm at 1320 Avondale Way. First thing that has motivated me to come down here is Ms. Chastity. I wanted again to look you and your staff in your face and tell you what a good job in providing information to this board. You did not give them an informational commercial. You did not argue one way or the other. You gave them a legal summary of where poor little taxpayers like me in the county stand, who don't have a voting right, and me, with my current legal situations, not even a voice with a legal municipality. It was assuring, it was empowerful, and it was validation for what I fight for every day, is that our local elected officials will be accountable for me. So to you, I tell you thank you. Commissioner Caban, my grandmama had an 8th grade education. But she always told me that if you don't stand for something, you'll fall for anything. I'm not rich. I can't even fake it. But I don't live in the city. But I pay service fees in the house I live on. I have another piece of property that's developed and another piece of property that's developed with current utilities. I don't like it when people just can tell me arbitrarily, without an explanation, without any information. And this is not something that just started. Commissioner Proctor, how many meetings have we attended when we watch our firefighters, their wives? For the record, my son's a firefighter. So it's not that I don't believe in supporting fire. I want to make sure, but I can't understand how can we have illegal levied taxes and our firefighters are the poorest paid. It's more to that. But I'm going to respect my time. You know, it ain't looking good. I don't want no problems at the curb.
Thank you, Mr. Sims. We have one more speaker, I think.
Dorothy Inman Johnson.
Ms. Cinnamon Johnson, name and address for the record, please.
Dorothy Inman Johnson.
Okay.
Do I need to give my address?
I mean, it's okay. I think we know who you are.
Good afternoon. I am here to speak on the fire service fee increase and ask you to do the right thing about all of the citizens. I've been talking about this for over a year and a half, making it clear that I oppose a fire service fee on citizens' utility bills, not just churches and reimbursing churches, but the people who are really overburdened by this are average residents of this community, people who are living in poverty, and I think the rate is about 20%. People, elderly, who are on fixed incomes, who struggle every month to pay their utility bill. And when you plop a fire service fee on their utility bill and then turn around and increase it by up to 25%, it is a regressive tax that overburdens the people who are least able to pay, and they will be pouring into our nonprofit agencies begging for help to keep their utilities on in the hottest summers and the coldest winters. I ask you to oppose the 25% increase on the fire service fee. There is no need for the fee, and I'm here as CEO of Citizens for Government Accountability, and we are in discussions right now on representation to file a lawsuit to prevent this unconstitutional fee on our citizens. And I ask you to think about the people who can't pay, who struggle to pay. Thank you.
Thank you. Next speaker, please.
Final speaker card on this item, Mike Nelson.
Mr. Nelson, name and address for the record, please.
Mike Nelson, 532 Oakland Avenue.
Thank you.
I was just coming up here to let you guys know that we have a serious problem in family law with the judges that are assigned to it. Most of them don't have the family law training which is required. A lot of them are acting in a conspiracy enterprise to extract and extort money out of people. I've had my signatures forged, government documents altered here at the courthouse, and 8 judges have all participated in that. That does fall under RICO Act also. We do need to get this under control because it's having a devastating effect on the children mostly. When we have a magistrate who's on a case, who then ends up representing another party in that case, then there's a problem. The financial fraud that's being allowed falls under RICO also. We really need to do this. This isn't just a Tallahassee problem. This is a statewide, nationwide, worldwide problem, and family law needs to be changed. But we do need to have some RICO investigations happening here at this courthouse with several judges, Judge Marsh, Judge Richardson, Judge Hobbs, Amanda Wall when she was a magistrate, Judge Wheeler, Judge Hawks, and currently Judge Miller. All of them have participated in this extortion, this RICO Act. I have all the records, testimony, recordings, audio, video. We need to get something done about this.
All right. All right, Commissioners, we are back on the item. Commissioner Maddox has the floor. You are recognized, sir.
Thank you, Mr. Chair. In order for me to be in right order, I'll make a motion for options 1 and 2. That's my motion.
All right, we've got a motion for options 1 and 2. Is there a second? All right, Dias
Mr. Chair.
second. Oh,
Did
yes, ma'am.
somebody do second?
You second? Okay.
I did, yes.
Okay, for discussion, we've got a second on options 1 and 2. Commissioner Maddox, go for it.
Thank you, Mr. Chair. We started this conversation a while back, fighting for a compromise because we didn't believe that the city was in the right posture to be able to raise the raises, and we wanted them to honor the contract that we had already agreed to a couple years ago. I want us to really focus on the facts of this and not participate in bashing the city or any one individual, because believe it or not, no matter what happens today, 2028 or maybe even sooner, we'll have to work with the city to come up with a compromise on how we move forward with fire services. I believe it will be very difficult for us to stand those up by ourselves, and so I want us to keep in mind, though, today, we walk away saying that we don't want to raise the fees, that ultimately it is the Tallahassee Fire Department run by the city of Tallahassee, and we will have to figure out how we continue to work together. And I've always been the one to try to be diplomatic in the way we handle our affairs with our partners, and the city of Tallahassee has been a partner of ours when it comes to fire services for years now. I don't believe that we would have been having the conversation about the fire services fee had the increase not been a factor. I believe that we would have finished that contract out, and then we would have renegotiated the contract in 28. And so for that reason, that's the reason I made the options 1 and 2. But instead, what has happened is a can of worms have been opened up because the city, after negotiations with the fire department, as well as numbers coming in at how much the fires union, numbers coming in on how much new stations would cost, sent over an increase of about 22%. Now we're looking at unfunded, underfunding, and spending that wasn't authorized, and a whole bunch of other stuff that we can dig into, while also trying to understand the fact that we have just made it affirmative that there will be no raise in the fee. What I ask today is that we focus on there will be no raise in the fee and stay with the current of what we have going on and renegotiate everything, including these things that we're talking about in option 3 when it comes in 2028. we can make whatever changes necessary then. Again, I want us to focus on the fact that if there had been no conversation about an increase, we wouldn't even be having this conversation today about all the other stuff that may have come as a result of the increase. And so all I'm asking, one and two, is that we get to finish out the remainder of this contract, which we asked them. What did we ask them from the beginning? We have a contract in place, and we ask that you honor that contract. We have a system in place that's working, and we ask that you honor that system. We ask for no changes to anything. That's what we wanted. Then we sent over a compromise that allowed for some changes, some increase in the fees, but it didn't change anything about the system. It just asked for some increases in the fees. And so again, what I'm asking for with options 1 and 2, and I appreciate Commissioner Cummings seconding, immediate past seconding my motion, is that let's finish this contract, just like we asked them to finish the contract. And when 28 comes, we can have all these conversations, we can make whatever changes necessary, and we can move into our new contract with the city, knowing we stand on good grounds of negotiation, because we did exactly what we asked them to do in honoring the way we do business right now. Thank you, Mr. Chair.
Thank you, Commissioner Maddox. Commissioner Minor, you're up, followed by Commissioner O'Keefe.
Thank you, Mr. Chairman. First of all, thank you very much to our county attorney and her office for preparing this agenda item. This is excellent, excellent work. It's a very complex topic. I had to read over certain passages multiple times, but it's extremely well done, and the research work that you and your team did is commendable. And Commissioner Maddox, thank you very much for your motion of options 1 and 2. I had been thinking about also adding option 3, and I may choose to do that through a substitute amendment at some point. Maybe one of my colleagues might too, but I've been listening very carefully to what you're saying. What our county attorney explained to us in the agenda item and just a few minutes ago was that we have a 5-year agreement with the city. That's a binding contract. And that contract can't be changed unless both parties agree to those changes. And what that means is that any increase in the fire service fees can't be made unless both parties, both the city and the county, agree to change that contract. That's a binding 5-year contract. We are just 15, 18 months at the very beginning of that 5-year contract. On May 27th, we discussed the city's proposal for a fire service fee increase. We disagreed with some of those increases, and so we offered what I thought was a good faith compromise, and I think everyone here probably agrees with that. They declined that compromise, and that's why we are now in dispute resolution. This board, based on comments that I heard from the last meeting, disagrees with many of those reasons for the cost increases. Me personally, I disagree with some of the increases because they are voluntary, meaning that the city has incurred these increases within the 5-year term voluntarily. It wasn't required. I think that given the fact that both the city and the county must agree to any changes to the fire service fee agreement, we don't agree with all those proposed increases. We had a good faith effort to try to make a compromise, but the city didn't want to go that way. Because we don't agree with all the increases and the reasons for those, I definitely support options 1 and 2. I want to hear from some other people here on the board about option 3. And the reason why option 3 is something that I think we need to consider is because our county attorney's office has identified things that could be, some things I think are very clear, where the fire service fee has not been consistently applied or imposed. Those are ways where we could increase revenue for the fire service fee and take some of the burden off of ratepayers. I want to make sure that we do our due diligence, that the city does, that this community does, to make sure that those reasons are carefully thought through. Because if the fire service fee has not been imposed correctly, and there's money on the table in certain areas, that's a disservice to all the ratepayers across the county and the city. I want to hear what my colleagues say about that item, but that's one thing I'm concerned about. I support options 1 and 2, but I want to hear from some of my colleagues about option 3. Thank you, Mr. Chairman.
Thank you, Commissioner Minor. Commissioner O'Keefe, followed by Commissioner Caban.
Thank you, Mr. Chair. First, I want to thank the County Attorney's Office, County Attorney and her staff, and also all the Vince and all our other staff working on this. A very complicated issue that we did not expect to be working on this year. And your work has allowed us to be at this position where we can choose not to increase fees for our citizens, and that means a lot. I have some questions. If you can remind us, what was the total cost of the requested increase, and how much of that was related to firefighter pay increases?
Go ahead.
I can jump in. The increase is about $2.5 million to the county per year. I don't have a breakdown of exactly what the share of personnel costs. We could probably get that to you.
I mean, wasn't the total increase request of 20% like $50 million?
22%, 14 million total we'd pay. It was a $7.5 million increase for the remaining 3 years.
Gotcha, 7.5, and only part of that was related to pay. Okay. And so since we sent our offer in June, the city declined it. Were y'all able to have meetings with the city administration to see if they had any counteroffer or anything like that?
We did. At the request of the city manager, Commissioner, we had, the county attorney and I had a quick meeting where we articulated our legal position, the one that's before you today, without variation from that. And certainly it was discussed that we could provide if there was another compromised offer, offered by the city, we certainly could bring that. I think we were pretty clear that that position needed to include no additional rate increases over a 5-year term. And it had to be, I would say, at least as good as the compromise offer offered by this commission. And at that time, there was no offer made by the city.
Okay. And then what we've learned through your hard work is that we cannot be compelled during terms agreement to increase the fee from the county. Can you confirm my understanding that the city can also not increase their fee on city residents if we don't agree under this term?
That's correct. Neither the city nor the county can unilaterally increase their rates. If they do, it will breach the interlocal agreement. It will not be consistent with the third-term rate study that's currently in effect.
Okay. And then we all love the MCs. We have another MC, the AMC, which is county administrator and the city manager. And how did we find, or how is it that the reserve fund was accessed and additional expenditures were incurred without joint approval that's in the contract?
All that we can tell you is that there was no agreement, official agreement on the utilization of the reserve fund to this point in the existing term.
And had you, forgive me if it sounds like I'm putting you on the stand, but you hold all the information here. Had you been made aware of access to use of the reserve funds prior to this issue coming up and looking into it?
No.
Okay. And then we are considering hiring a financial consultant to look into the records, to make sure that each side of this agreement is funding as they're obligated to and only spending as they're authorized to. How is this financial consultant, should we approve it, different than what the financial consultant did in the work before on the rate study?
So the consultant who developed the rate study was jointly retained by both the city and the county. The methodology that's used in the study was developed years ago. Most recently, what they did was they simply plugged in numbers that the city provided to them related to increased cost and developed, it's mathematical, what those rates would look like to fund the increase in costs. What would be envisioned if the board approves option 3 is the county would retain its own consultant who would not be retained by the city, who would review the city's documentation to validate and quantify the amount of any underfunding, validate whether they trued up, validate the amount they should have imposed under the flat rate, but haven't, since they adopted the resolution in 2023, and would do those sorts of things. So the engagement would be strictly on behalf of the county.
And would that work? Is that work all allowable and part of the agreement that we've made with the city to be able for each party to do that? The work, the consultant, the work that we would ask the consultant to do, is that all part of what we're able to do under this agreement? It's not a new separate action?
It's not prohibited. It would be something we would do under the dispute resolution provision in the interlocal agreement. So it is permitted.
Okay. And then here's the important question for us. If are you comfortable that we, in all our books and records, have met all of our funding obligations to this point of the agreement? If we're gonna look on that side, we need to make sure our side is good.
There is one area where arguably the county did underfund related to Arbor Landing. You may have seen an article in the paper about that. That was recently identified. I believe the county administrator also sent supplemental information to the board about that. If we determine that there was underfunding by the county, there would also be an obligation of the county to true that up as well.
Excellent, which I would expect we would do at the appropriate time for that. Thank you very much. And so, first, I support firefighters and pay increases that are well-deserved for them. But when we look at this 22% increase request, it is mostly not for firefighter pay, which is important. Now, once we know what money might actually be coming in and out from the city, funding and expenditures, and where the money actually stands, we can, I think, then start looking at this is a basis for if there needs to be more money. After all of that review and due diligence is done, that's a reasonable conversation to have. But that's not where we are right now. We have an agreement, and we need to make sure that the other party is paying their fair share and following the terms of the agreement, just like we pay our fair share and when we find out if that's not the case, we will resolve it and honor our terms of the agreement. We are equal parties to this agreement. I don't want to increase fire service fees on citizens when we have a 5-year agreement with the city that we were able to tell our citizens that will stay flat. And that rate may not be the source of the shortage, as we found out. It may be issues of, is the correct funding being put in by the other party, and are expenses only what's being allowed under the contract? We are an equal party to this agreement, and we represent citizens in the unincorporated and incorporated, but in this case, unincorporated area, that rely on this critical service and pay for this critical service. And we have a duty to hold ourselves accountable to the agreements we make, and we have a duty to hold our other parties to our agreements, to the agreements they make. That's why they're there. I think if something similar happened with the corporate board and they had a midterm 22% fee expense increase request from a vendor outside of the terms of their contract, I think that corporate board would do everything to verify and dig in and make sure it was a valid and necessary request and required under the agreement, which we are trying to do. Now it sounds like we have to. And they would do that because they owe a duty to their shareholders, and we owe that same duty to our citizens. We have already found possible errors by the city, not meeting their funding obligations, and not honoring expense limitations. And I think we just need to verify everything before we go and change 2 years into a 5-year flat fee agreement. Once everything is reviewed and verified by a financial consultant, and if an increase is warranted and we find that the balance of the fund is where it needs to be because everyone's paid their fair share, that's the time to discuss what a reasonable, necessary increase might be, if there is one. But we are not there now, and we are not there this year. And so that's where my thinking is on this. And I am, again, we are just verifying that we're honoring the agreement and that our colleagues are honoring the agreement, because that's our job. That's what we sign up to do. So I make a substitute motion for options 1, 2, and 3.
All right, we've got a substitute motion for options 1, 2, and 3, seconded by Commissioner Caban. Still in discussion, if you got anything else?
I'm done.
Okay, Commissioner Caban, you're up. Mr. Vice Chair.
Thank you, Mr. Chair. Commissioners, I have a handful of questions for the county attorney, but prior to that, I do want to say a few quick things. One, I want to echo some of the sentiments that have been shared by our colleagues, and I want to commend the county attorney for her diligent work on this issue. I think not only has she represented our board very well, but I think that, Madam Attorney, you represented the constituents and our taxpayers in Leon County very well. And this agenda item was detailed, it laid out the facts, it gives, I believe, 3 options that benefit residents not only in Leon County, but also in city limits that we also represent. And I think it's important to remember that as we go through some of this process, is that we're county commissioners and we represent folks in the unincorporated and in the incorporated. Next, I want to firmly say now more than ever that it's important that we have adequate funding to make sure that the brave men and women in our fire department are compensated fairly and have the resources available to them to do their jobs at the best, highest, and professional ability. And I think this issue is truly about making sure that we are prioritizing public safety while also maintaining fiscal responsibility and trust for our taxpayers. Madam Attorney, I have a few questions that I want to discuss with you, and I know we went through this in our briefing. And the purpose of these questions, commissioners, is there's been a lot of misinformation in the media about this issue, and I think it's important that we just cut straight to the facts. And so for folks who are listening and folks on the record can understand like what's fact and what's not. Mr. Chair, may I address the Madam Attorney?
Go ahead.
Madam Attorney, in our May meeting, did the county make a good faith effort to accept a reduced rate?
Yes,
Did the city decline?
yes.
From my understanding, I think it was said earlier in this meeting, the city cannot unilaterally raise the fire services assessment rate, just as we cannot raise it without their acceptance.
That's correct.
The third term rate study was mutually approved by both the county and the city. The city then issued $10 million more in debt than they were initially authorized. If the county administrator does not approve that, it's not permissible. Is that correct?
That's a violation of the interlocal agreement. That's correct.
Is it possible that the city spent additional funds outside of the third term rate study that were not approved?
It's possible. We just don't know.
And is it correct that state law requires properties must be assessed in an amount that correlates to the benefit received, fair, reasonable, and uniform?
Fair and reasonably apportioned, that's accurate.
And some churches are paying the fire services fee assessment and some are currently not paying.
That is my understanding.
Is it correct that the city of Tallahassee has a resolution requiring them to true up for properties that receive fire services yet are not collecting due to the cessation of utilities?
That is what the resolution says.
And have we asked the city if they are truing up on these properties that are not receiving, that are not paying into the fire services assessment?
We have.
And have they responded?
No.
Is it also true that the city of Tallahassee does not collect fire services assessment from accessible properties, both unoccupied and occupied, that do not have an active utility account?
I'm so sorry. Can you repeat that for me?
Is it true that the city does not collect the fire services assessment from accessible properties, both occupied or unoccupied, that do not have an active utility account?
That is my understanding.
And that has been confirmed by a city staff member in the meeting with you and the county administrator?
That was a statement that was made, yes.
And the city of Tallahassee did not impose the rates established in the third term rate study.
That is correct.
So the city billed an incorrect rate over the last few years that is a lower amount than what was agreed upon in the third term rate study.
Yes.
So this means that the city has underfunded their portion of the fire assessment reserve account.
To date, that's correct.
And if they are not truing up their missing fees or underfunding the account, does that effectively penalize county residents by implementing a rate hike?
You could draw that conclusion.
And then on the option 3, I think option 3 is important. We currently do not know the truance or depth of how much the city has underfunded the reserve account. And this option would just give you direction to use your office budget, which is already in budget, to hire a financial consultant to see how much the city has underfunded the reserve account.
That's correct.
Okay. Commissioners, I wanted to ask those questions, and we discussed this in our briefing, because I think it's more important now than ever that we dig into this issue. Sure. We are seeing, and we were asked by the city to blindly rubber stamp a 22% increase on our residents across Leon County. This board made a good faith effort to say, hey, we're not going to push back, we'll meet you in the middle. I think that was a collegial move, I think it was a statesman move. I wasn't for it because I firmly believe that what's happening is wrong. Commissioner Proctor, I know you weren't for that either. There are big issues with this fire services assessment. It's my opinion, and what we're seeing is that this is not being imposed fairly. I would argue that what's happening is we are sticking taxpayers, hardworking families, and residents with the bulk of this bill. Meanwhile, other folks are not paying. It's not fair and it's not uniform. Additionally, the city claims that there's not enough money to fund fire services, yet they are billing the incorrect amount. They're not collecting the fee from cities, from properties in city limits uniformly. They are overspending on capital improvements without the county's approval. That in itself is a violation of our agreement. And I think it's important for us to remember, as I mentioned earlier, we represent Leon County. Folks within city limits are our constituents too. And I think it's wrong to blindly try to increase this fee or accrue costs when we have an agreement and not seeking approval by the county administrator and our board. I think the only way forward, in my opinion, is to have true closure on this issue, is for us to dig deeper and listen. If our board, Mr. County Administrator, if we underfunded portions of this account, we deserve to true up as well. I think it's wrong for us to go to the city and say, you need to true up. We owe it to taxpayers to true up. I know the city of Tallahassee has a ginormous reserve account that they're sitting on, and I think that we need to dig deeper into this issue. I think we owe it to taxpayers. We need to find what the delta is from the city and the county, but we need to make this account whole, because I think it's wrong to increase a fee on residents 22% without managing this fee properly. And I think that is what's been asked of us, and I'm proud of the fact that we're at this point in pushing back. And commissioners, I hope that, and that I trust that we can get to a point where, we have unanimous approval on options 1, 2, and 3. Thank you, Mr. Chair.
Thank you, Mr. Vice Chair. Commissioner Cummings, you are recognized.
Thank you. Thank you, Mr. Chair. I appreciate the comments from my fellow commissioners as well, and I certainly want to thank our county attorney, for the legal analysis that she has provided to us as far as the status of this dispute resolution as it relates to the rate increases. I think it's very clear. Certainly thank our county administrator and staff for the written analysis that they have provided and, of course, given us the options that we have. But I'm ambivalent, commissioners, and I think I take a little different look at this and a little different approach to what we have before us. As Commissioner Minor pretty much reiterated in the county administrator as well, the history of what got us here. And what brought us here was the city putting us on notice that we needed to raise the fire services fee by between 22 and 25%. There's a motion on the floor to accept options 1, 2, a substitute motion, options 1, 2, and 3, okay? If we accept the substitute motion or even the initial motion, it calls for us to authorize staff to rescind the dispute resolution process as it relates to the rate increase. And I think it'll probably pass unanimous. Okay. And it also, option 2, directs staff to go on and send the statutory notices that we will be retaining the same rate for the next fiscal year as the current 2025 rate. So in my opinion, if options 1 and 2 passes, we've already resolved the issue that the city has raised. Now, mind you, staff has done a great job in looking at the city's articulated reasons for the increase, okay? And in the process, staff has also uncovered some areas that we believe leaves the city vulnerable. But at this point, I'm not clear and I'm not sure whether or not our taxpayers will be at an advantage or disadvantage on a couple of these. Initially, one of the primary issues is the allegation that the city underfunded the fire services by really not assessing properly, under assessment. If that issue goes before the arbitrating panel, hypothetically, they could find that, yes, the city has under-assessed, and my concern is whether or not the arbitrators could go back and order the city to recap that under-assessment. That wouldn't be good for our taxpayers, in my opinion. If the arbitrators have the authority, and which I understand they could, to go back and require the city to collect those areas that have been underfunded, which could very well include our very taxpayers that we are trying to protect right now. South also uncovered an area where they believe the city did not supplement properly for those properties that didn't have utility accounts. And I believe under the agreement, the city was to supplement the fire services fee with non-city fire services fee, or from a different budget resource. They didn't do that. But if they have been found to have violated that provision, at this point, we don't know how much that would be, whether it's a de minimis amount, whether it's a significant amount. I mean, we don't know. We could be going down a rabbit hole. Now, one of the things I believe the county administrator said we know definitively is that money was taken from the reserve fund without approval of the administrative management team. And I think perhaps that could be refunded. But at this point, there are parameters that the arbitrators could take, in my opinion, that might not be beneficial to our taxpayers. And I think ultimately, we as a board, we look at taking actions that's going to benefit our constituents and our taxpayers and make sure the fees are what we agreed upon. So if we vote for option 1 and 2, we have assured that the taxpayers are going to be billed the fee that we agreed upon. Okay? And whether or not we as a board, okay, we would have done that. Our contract is satisfied. So my question is, do we want to go further and dig into these other areas which I believe have been legitimately raised by our staff? It's question marks to me whether it would be beneficial to the taxpayers or not. But I think today, keeping the rate where it is based on what we have agreed upon in this 5-year agreement with the city, I think we would have done our job and we would have protected the taxpayers. Now, as a sitting commissioner, I would hope and pray that these two governmental entities could work cooperatively, could get along, do what we can for the benefit of the taxpayers. And I think if we do that, it doesn't require that we ask the arbitrators to scrutinize what has taken place the last couple of years, as long as we're protecting our end of the contract, and that's taxing our county citizens at the level that we agreed upon. I just think that beyond that is setting a policy from this board. It might take us down a rabbit hole, and we don't know what's at the end of that rabbit hole. And I'm saying this just so that we can think about what we're saying, so that we can think about the actions that we want to take today. I came here today to make sure the taxpayers are protected. We did that 2 years ago when we signed this agreement with the city. And if we in fact vote for options 1 and 2, we would have done that. Option 3, and I appreciate staff, I appreciate their ingenuity, I appreciate their ability to look at issues that we could raise, that we could go to arbitration about, but that has nothing to do with the rate that we agreeing to tax the county taxpayers. It's the rate we agreed upon. And I think, as the county administrator said, when he gave his analysis initially, this is only a 5-year contract, and is subject to 2 one-year renewals. So at some point, we will have to be at the negotiating table with the city for the provision of fire services. The county does not have these fire departments. We rely upon the city, and they are paid to provide that protection to our county citizens. So I want us to be in a strong position for our citizens, and I want us to be diligent, but I think perhaps we might be going beyond where we need to go if we move forward and try to negate the reasons the city has indicated that it wants to increase. I mean, they can say anything they want, but we, I believe, are going to agree to keep the rate as it is. And I'm saying we would have done our job. We would have enforced what we agreed to 2 years ago with the city. These issues, I think, would be raised soon enough, perhaps, when we negotiate new rates, and that will be done, hopefully, after a study, just like a study was done when we entered this contract with the city 2 years ago. But my point is, why raise a fight when we don't know what the outcome is going to be? I don't know if it would be beneficial for the citizens that I represent. And right now, I think that a decision to maintain status quo, and I think we would have done a great job in doing that with all the analysis that we have, with all the information that came from the city to substantiate why the rate should be increased, with the research that the city can't unilaterally raise the rates. It has to be an agreement between both parties. I think we would have done, we have done a lot to arrive at this point, to say status quo. We're going to protect our citizens. And I think we should keep it there. And negotiations will come soon enough. Thank you, Mr. Chair.
Thank you, Commissioner Cummings. Commissioner Proctor, you have the
Thank you, Mr. Chairman. Yes, Commissioner Cummings raised the question, why would we go beyond the point of going beyond what we need to go beyond? For me, it's simple, and it is that wrong will remain on the throne as long as right refuses to fight. The city's been wrong in fire services fees, its assessments, its rate, and I suspect that in this particular room, the only person who's read more county commission agenda items than myself is Vince Long. I've read a few of these things before, is what I'm trying to say. I have never seen our staff tell us as poignantly that wrong is occurring in the city's rates, assessments, leveraging, and the very different methodologies that are being applied. So for me, we go further than status quo because the bells are ringing. Our staff has never been as pointed in saying this is bad. So to former Mayor Ms. Johnson, who said to us something about the firemen, the struggles with the firemen and being paid, and though we cite and reference firemen pay. And I want to also begin my discussion with the letter attachment 2 that our chairman sent to the mayor and the city commission on May 29th. And I also want to limit my initial thoughts to attachment 3, which was Mayor Daley's response on June 12th to our chairman's letter to him after our board extended a compromise less than the 23% that they sought to raise. But in the area, Commissioner Cummings, of when it comes to the city and fire, you're aware, it's taken the city years to get a fire extension. You're aware that everyone in the city got a 5% across the board except the firemen. You also aware that you read 3 or 4 weeks ago that the churches, some are exempt and waived from fees and some are not. You were sitting here as we were when in the middle of, after 15 months, the city offers to mandate that and we wouldn't be here today had we just shrugged our shoulders and went with the status quo and said that our Heavenly Father, the city government, has told us to allow them to pillage and rape citizens of this community undeservedly of being pillaged or raped. And our staff has told us there's a problem, false, in a way that is screaming. And I can't ignore that, and based upon the history of the conservative manner and politically correct that this staff has been over the years, for them to put something to us this absolutely clear, and we would not go further. So I want to answer that question. It helps me to feel good. Madam Attorney, might be the chairman's response here. In the third paragraph of the May 29th letter, Mr. Chairman, you said that in January of 2025, that we received a letter from the city, and it indicated that there was sufficient funds remaining to carry out the contract to fulfill what was needed. And the need, quoting, the need to adjust the rates due to non-payment for services by Leon County schools and the adoption of a new collective bargaining agreement for firefighters, again, pay. I heard, I believe you were referencing Table 6, Mr. O'Keefe, and you indicated that based on that study, and I had it in my notes to ask you on that table, was any of this stuff valid stuff? Table 6's calculation that talks about assessable costs for 23-24. And these assessable costs, some of them, I'm not an accountant, but you mentioned it and you satisfied my curiosity that these ain't no assessable costs, but it's thrown up in here. But we were told, that we recited, Mr. Chairman, in your letter to the mayor, that in 2025, the mayor said to you that there was a need to adjust their rates for fire because of Leon County schools and because of a new bargain agreement. Your letter further goes to say that we retain Accenture, a third-party consultant. Well, it's also been brought to our attention in later days that fire station number 17 has been, since we've returned down this off of the city for 20-some%, now we have at us an additional variable, and that is $28 million for fire station number 17, which was not even cited in the initial recapturing of what initially was brought to our attention in January, Mr. Chairman. I'm still looking at your letter, Mr. Chairman. It indicates that we would agree with the city if in fact term number one, that if they would agree that the adjusted rate for fire service assessment and fees for the remainder 5-year assessment period will exclude all costs related to ISO ratings. And as I look at the mayor's simple letter to you, a complicated letter you sent, and the simple 1, 2, 3, 4 paragraphs in his closing response to you of June 12th, I find something additionally coming out now. The mayor says that the ISO rating would lower, let me quote, first of all, in this letter, the mayor says that the city commission voted at their June 11th budget workshop. They voted unanimously to follow the recommendation of the fire chief and move forward with investments in the fire services to increase its level of service and response. That's not what originally he said, to increase the level of service and response. We got a letter from him, your letter to him, Mr. Chairman, says that they were going up on the bills because of the Leon County schools, which had not paid their bill. And he said that they're going up on the cost because of the collective bargaining agreements for firefighters. But then in June, the mayor comes back and says that he is following the fire chief to increase its level of service and response. Now, I'm not the smartest guy in Tallahassee, but I know two different rationales when I read them. I don't always hear well, but I know it when I read it. And I'm trying to say that the mayor has thrown and made a scapegoat out of the fire chief, done throwed him under the bus. And I know nothing that a fire chief sets rates and assessments and does financial studies that the city commission follows and adopts as its rate standard for fire recovery. That's just too hard for me to reconcile. We might be running a little low and a little slow at the city, but I don't think that we've just boiled down to just soup and bones. We ain't that low, that the fire chief is setting rates to determine his response to. So I'm conflicted in my understanding. Now, Mr. Chairman, your letter indicated that we would get a censure. And if I'm correct, a censure has stated that instead of a 22%, their assessment was for a 17% increase. But the mayor and the city commission would not compromise and meet us at, we didn't PFTA, we didn't pluck this from thin air. We got a consultant, and based on that consultant, we extended an olive branch at what that consultant found to be a number that might work. And the mayor slammed the door in our faces and said, nah. So we're here today because had they walked on the 17%, we wouldn't need to be here in the middle of August on vacation coming off to be here to talk about this. Well, the ISO, county attorney, I come to you. The mayor has said here, while to you, Commissioner, to all of us, members of the county commission, while your May 29th, 2025 letter ties this investment to ISO ratings, in reality, the investment is to implement the chief's plan to increase the level of service to our community. Po Chief got his back bent over and the mayor's riding hell out of him again. It's crazy. In the history of Tallahassee, no poor fire chief has ever had to bend over and get his back ridden for something that he's not responsible for at all. But it's a metaphor, and we get that. I want to ask you, County Attorney, this is critical. He's going to follow the chief to increase the level of service. All before in January, he needed to make the adjustment because of Leon County Schools and because of the collective bargain agreement. But in June, he's just going to follow the chief. I'm not going to think, I'm just going to follow my chief, which we are confident will result in a higher ISO rating. A higher ISO rating in turn can lead to reduced property insurance rates for residents and businesses. Madam Attorney, can you tell this board, this letter that we've got, can we lean on this and confidently state that there's truth to that? What relationship is the ISO that the mayor is wanting us to go for in its relationship to reducing premiums for property?
So Commissioners, in the course of preparing for arbitration, I did contact the Office of Insurance Regulation, which is the regulator for insurance companies. I asked them to look at whether, in fact, an ISO rating change would have any impact if the ISO rating was a 3 to a 2. Based on their review of the filings of the top 5 insurance companies specific to Leon County, there would be a 0% saving in insurance premiums when there is a change in the ISO rating from a 3 to a 2.
So I can't rely on the mayor's third paragraph to us, is what you're telling me as my counsel.
I can validate based on the insurance regular information that there would be no cost savings to constituents.
Okay, so the mayor's letter to all of us from June 12th indicates that the second paragraph, that this investment will only cost residents about $1 a month. It is unquestionably an investment worth making. Ms. Long, can you tell us that this 22% equals a $1? Is it a $1 per month ask, or can we rely on that paragraph? If anybody knows in the house.
I believe that was roughly what it came out to.
Again, the city bills monthly on the utility bill, so it's about $30
Annually.
annually. A little less.
Okay, so if it's $30, O'Keefe, how much that is? $30 annually, but the mayor says it'll be about $1 a month. Is that, I'm just asking Mr. O'Keefe his expertise.
About $250 a month.
It's about $1.50 short a month.
Okay, I just want to know if I can count on it. I can't count on it. So I'm just looking here at the final comment that the mayor made to us June 12th. The city recognizes the long history of Tallahassee Fire Department servicing all Leon County. We believe that this relationship will continue to ensure all the benefits from this increased level of service. But he said, your letter, talking about you, Mr. Welch, asked the city to agree not to seek any future increases to the fire service assessments. And he says, the city cannot guarantee that adjustments for unanticipated changes in costs will not be recovered. So even if we bend over and go with this increase, the mayor has told us in our faces, we cannot guarantee that adjustments for unanticipated. And see, the city's always got unanticipated. That's unanticipated. That's why we had that lady to sit down here at this table. And she presumably was the independent party working with the city. But the truth is, when I asked that lady, where do you get your numbers from? That lady said, the city gave them to me. Well, this is a game, and I think that the first recommendations of 1, 2, and 3 are, if we do not stand up for this community as I look around and see ministers on the back wall. A meeting was held in this community last night with respect to churches. Some being assessed, I guess, at a flat rate, and others being assessed with a mixed variable of executed methodologies. And what we found from the literature here is that flat rate do account at some, and we have a mixed variable combination of other dynamics applied to others. And this is a very interesting thing, that attachment 1 on page 2444. It talks about exemptions and impact of exemptions. And I found this interesting, ministers, that in our fire world, the crafting of an exemption must be founded upon a legitimate public purpose and not tramp on state or federal constitutional concepts of equal protection and constitutional prohibitions against the establishment of religion or the use of public treasury directly or indirectly to aid religious institutions. I know that something is wrong. This language is wrong. And the practice is not consistent, even though it cites equal protection. But it is not equal protection when some are flat rated and others are taxed on something else, multi-tiered something. This is why, Commissioner Cummings, your walk with us on this 1, 2, 3 option is important. And your grasp and understanding of constitutionality and equal protection for all of our citizens in this problem. And I've got so many other thought frames, but I'm starting from the back, working forward, and I'm not going to go all the way. Because Florida case law prohibits the shifting of the fiscal cost of any special assessment from exempt landowners to other non-exempt landowners. In other words, this is critical, Chastity. In other words, I'm reading from this thingy, the funding for an exemption from a special assessment must come from a legally available external revenue source, such as the city and county's general funds. I'll pull up right there. So, to the underfundingness of it, the city has to pay, or the county has to pay. I don't need anything further than to read, to see that, to note that the underfunding has to be covered by the city or the county. All of these exemptions, all of these waivers, I'm just reading the law and what needs to occur. So it concludes, funding for fire assessment exemptions cannot come from the proceeds derived directly from the imposition of special assessments for fire services and facilities, because any exemption must be funded by an external funding source. And that's the problem here. So to Commissioner O'Keefe's ask, his initial ask was, first of all, these categories accessible. But even if they were accessible and waivers and the under asking for funds, that's going to have to come out of the city's coffers. But I know that Commissioner Cummings has rightly recognized and restated for us that that word mutual agreement, that it takes our surrender to the ask of the city in order for them to shear county sheep, and we get none of the proceeds. So we have the opportunity to stand tall, to stand for what's right. And again, I believe that right will stay on the throne as long as right refuses to fight. And as long as I'm a county commissioner on this dais, I'm willing to fight for right, in particular when wrong is on the throne. So I encourage all of us to support options 1, 2, and 3. We will get a second round of, we will get a second, I'll yield.
Thank you, Commissioner Proctor. Commissioners, I've got basically everybody in the queue again. All right, I'm going to take my turn, and then we'll go around again. I got Commissioner Maddox, Minor, O'Keefe, and Cabaner in that order for the second round. First and foremost, Commissioners, I know the City Commission is listening to us right now. I mean, I assume they are. And I hate that this has become adversarial in that nature. And I texted the mayor yesterday and told him, you know, I thought his service was admirable and, you know, thanked him for 8 years. And I think that it's humble to walk away and, you know, to take that upon yourself and make that decision. And so I want him to hear that, and I want us to sort of put ourselves in that frame of mind. I admire anybody that's in the arena having these conversations. They're not personal. I don't want to attack the city commissioners or the mayor or the city. I want to be as like rational and pragmatic about this as I can. And as I look at this issue, you know, my inclination was to frustration, and I was like, this is, you know, the city's telling us, they just telling us what to do. You know, we need money from you to run the fire services, and we want to do this, we want to do that. And I think I said something to the effect last time that, you know, we don't get to choose. The city runs the fire department, and I think that's important for us to understand. The city, or to recognize, the city runs the fire department, and we dance with them. I told my students, we started school this week, I said, look, you know, note-taking in class, it's like a dance. I'm going to give you some information, I want you to ask questions, and then we want to dance. If I'm just up here talking, we're not dancing. And I'm just going to leave, and you can just read the book, and, right, I want to dance with you. Well, that requires two, right? It takes two to tango. Well, when Commissioner Maddox proposed a compromise at the last meeting, if you guys recall, or the last time we talked about this, I was kind of hung up on it, right? I'm like, man, I don't really know which way to go. I was frustrated with the city and this imposition halfway through an agreement of more fees that we have to then pass along to our constituents. And I went with Commissioner Maddox's compromise, and I would say it was well dismissed by the city, I'd say probably with prejudice. You know, we're kind of told we don't know what we're talking about, you know? And that is a sort of another kind of slap in the face to the county, and this idea that, you know, just leave us alone, little government. We'll do what we want to do with our fire department, and you just come along with us and don't have a choice. And so I feel like through this process, we've accomplished a couple of very important things, which we've all acknowledged, which is we have established that the city cannot just arbitrarily raise the fire services fee, not even for themselves inside the city limits. They have to have our approval because we are dancing partners. Now, when I think about that analogy, I think to myself, you know, the city is Johnny in Dirty Dancing, and we're Baby. All right, we can say we're the same, but we're not the same. They're Johnny, and we're Baby. But we know from that movie, nobody puts Baby in the corner, right? And so I feel like we are obligated to some extent to go with option 3. Staff has given us that option and said they recommend that for us. I think that although I represent one little corner of the county, I represent 100% of the people in my district. 75% of those people live in the city, and I represent 100% of them too. And I think that we have a duty really to at least say, hey, look, this is not, we want to provide the best services possible to all of our constituents, and we are no different in that way than the city. We also want to make sure that we're doing it in the most fairly applicable way possible for the least cost possible. And I have supported the fire services fee increases in the past because obviously we want to support first responders, we want to support our firefighters, but the drip drop of fees and expenses and taxes and all these things on the cost of living to our constituents is such that at this point in time, to come back 18 months into an agreement and ask for, not really ask for, demand, right? They're not asking us, they're demanding that we increase the fee another 22%. I think that it warrants us as a dance partner to go, hey, you're stepping on my toes. It's okay to tell your dance partner, you're stepping on my toes. I'm trying to do the best job I can for the people we're dancing for, and you're stepping on my toes. And I think that there's nothing wrong with us saying, look, and again, in good faith, I don't think we're being antagonistic here. We were put in this position. We're not being antagonistic by saying, look, there may be some applicability issues here. The uniformity of the rates application is not evident to us. Not only that, you're spending money that you haven't asked us to agree to you spending. I think we have some responsibility there, actuarially, from a oversight perspective as dancing partners to make sure. If I come home with a Corvette, my wife's gonna say, where'd that come from? Right? I can't just go, I just borrowed money to buy it without your permission. That's gonna cause problems in our relationship. So she has a duty to go, well, you really shouldn't make those kinds of decisions. You need to return that. We'll look at that in 3 years and see what our finances are like then. Well, that's why we have a 5-year fire services fee agreement to take into account what's needed all the way through. And then we'll commit to that, and I will likely commit to that in the future. It definitely adds to the frustration that we know that not all of this increase is going towards salaries, and that's just a portion of it. I think we all support increasing the salaries of firefighters. I think that the city supports that too. I think another thing about option 3 that hasn't been discussed is the idea that Part 3 will also ensure that we are funding the fire services fee to the capacity that it needs. Because right now we don't really know, we're kind of lost in the dark. So as a part of taking a deeper look at it, we're gonna find out maybe we do have to do some more, right? We've already sort of acknowledged on this board that there are things that have happened in the fire services, in the cost of fire services that the city could not anticipate, like the negotiated new contract, right? I think that a bigger portion of the concern are the costs of some of the equipment, the ISO rating, the cost of some of the facilities. And, we keep getting more information, like the ISO rating changes is not necessarily going to impact rates for our constituents. So I think there's this mass of information that we have gotten that just as a responsible advocate for our constituents, we owe them that analysis of that. Just as stewards of that money, we're asking them to pay that money. We should ensure that it's necessary before we do that. And I think that the function here is to do that, to find out what exactly are the costs, what exactly has been collected, what hasn't been collected, and can we do it better? And again, it's not meant to be adversarial to the city, it's meant to be accountable to voters and constituents, which all of us want to be. Our city partners as well, they want that as well. So in that vein, I tend to want to support options 1, 2, and 3. Again, I just want us to be, I wish we could be less adversarial, less provocative towards our city colleagues. It's frustrating to me, trust me, because I've tried to lift out the hand of compromise and it kind of got slapped back at me. But that doesn't mean that we give up on that idea. But I feel like number 3 is not as, I totally understand where Commissioner Maddox and Commissioner Cummings are coming from. We have really accomplished a lot by just establishing that we have to agree to any rate increases. But look, sometimes when you're searching for one thing, you find another. It doesn't mean you turn your back on the thing you found, right? If you're looking for one missing puppy in the woods and you find a whole litter, are you still obligated to take the rest of them back to the pound? You can't grab the one you're looking for and roll out. So I could come up with those things all day. I'm just saying, that's the point I'm trying to make. So I hope that's salient to you guys. But that's the way I feel about it. And again, I don't think it's adversarial. I think it's advocacy. We are looking at it and we're going, hey, I know we're the smaller dance partner, but help us make you better. All right? Baby made Johnny better. Right? And that's the way dancing should be. Everybody should be helping each other. So that's where I'm at on it, commissioners, for at this point. And I've literally got everybody back in the loop. So if that's cool with y'all, we'll go around again. Commissioner Maddox, you are up.
Thank you, Mr. Administrator and Madam Attorney. When we started this conversation, what was the basis of the conversation? I'm talking about when we started the issue of fire services fee, what was the basis of it? What were we discussing? What were we trying to compromise and fight against? Can you answer that question?
I'm sorry, Commissioner Maddox, can you just repeat
When we
that?
started the conversation, when we started the issue about fire services and the fee, what was the issue in of itself that we were battling with the city?
Our position was and is very simple, of course. Chastity can elaborate and provide way more details, but our position is that a 5-year fee is a 5-year fee is a 5-year fee.
That's all I need. Would you agree that was, Madam Attorney, that was where we started?
I believe that was an accurate reflection of the position, yeah.
Thank you. My best friend has this quote that he likes to use concerning feces. I'm going to attempt to be a little more articulate. There's two models of thought in my head. One is modeled by Oscar Wilde, where he says moderation is fatal. It's a fatal thing. Nothing succeeds like excess. Quite frankly, given where we started, I believe that the issue that we fought for was to be no increase in the fire services fee. I would say option 1 and 2 does exactly that, and we can call that a win. Anything over that would be excess. But to some, excess is not necessarily a bad thing. Other frame of thought is one I've been given from Shakespeare. He talks about gilding refined gold and painting the lily, throwing perfume on the violet. When you win, you win. Again, we've asked for the city to honor this fire services fee for the extent of the contract that was put in place. A lot of the argument that I heard around the table today for option number 3 was, well, we need to go ahead and look at this before we justify an increase. We need to make sure that we're doing everything we can before we look at an increase. There will be no increase. We're not even discussing an increase. Everything that happened before today about an increase does not even matter. The letter that came from us, which was a bird in the hand to the city that they said no to, is irrelevant now. The reply that we got back from the mayor, who said that they needed to increase, again, irrelevant. What we fought for, we got today through the good hard work of the county attorney and our county administrator, in that the contract says that the city cannot increase the fee without us saying okay to it. We can continue to dig, we can go with option 3, but quite frankly, I think nobody articulated better, not even myself, than my immediate past chair and at-large better half, when she said, are we protecting our constituents with number 3? Because that's what we're here to do. And if there is underfunding, who's going to have, do you believe that we're going to take out of our coffers, or the city is going to take out of their coffers to do the underfunding when we just talked about a 22 to 25% increase? No. Those fees are going to be passed on to our constituents because we were underfunded, which means they should have paid more. Now, the issue about the reserve account being used, and county administrator said he had no idea it was being used. I would venture to say that if it was reasonable, what they were asking for the reserve account to be used for, that we probably say yes. we probably would have. I mean, it's a reserve, they have the money. How many times have we used our reserve to cover things that we had to cover so we wouldn't have to go increase our fees? So I would imagine that we'd probably say yes. So to me, okay, moving forward, city, I would ask that you didn't do that again. But odds are, again, we would have said yes. So now we're talking about the underfunding. Underfunding, we don't know how much that would hurt, how much that would hurt our constituents, how much that would increase their fees, or what would happen there. But what I do know today, that option 1 and option 2 puts us in a position to do nothing to our constituents, to not increase any fees on them, to keep the status quo and keep moving forward until we finish this contract and we can look at what we may need to change moving forward. Again, I just don't see us. I don't see a reason for us to refine gold. I don't see. Lilies are beautiful in and of itself. Why are we painting them? Why? Why are we even having this conversation? Again, everything I'm hearing, well, we got to do this before we raise the fee. The beautiful thing that's happening today is we're saying that they can't raise the fee. Even more beautiful than that was we sent over a compromise that would have given the city the opportunity to raise the fee that they shouldn't have been able to raise anyway. But they said no. And now we sit here and we get to say back, you had that bird in hand compromise. You said no. Now we're saying that you can't raise the fee at all because this contract gives us the authority to say whether or not you raise the fee. But what we're going to do now is we want to go a step further, and we're still going to arbitrate, and we're still going to look at other things that within this system that we're talking about that nobody would have complained about. Nobody would have complained about had the increase not come from the city. So that's what we're going to do. That's what we're going to do. But like I said, in 28, we may have the position of power now, but in 28, we have to go back to the city. In 28, we're going to ask the city, hey, we want to renegotiate and work with you all on the fire services fee. And we want to see if we can come up and fix all the problems that we had and all that kind of stuff. In 28, that's what's going to happen. In 28, just around the corner. Or let's say they say, hey, you don't want to increase the fee, then we'll just go ahead and we'll just cancel the whole contract. We got to give you 18 months. At least I got 18 months sitting steady at where we at. And then at 27, we can do the same thing. But what we're talking about here is going to arbitration and looking at this and looking at that and underfunding and maybe even having to pass those costs on to the people who are underfunded, whether it be business or it be a residential and all that good stuff. I just, again, why are we trying to paint a little? Let's just take the victory, man. I mean, if we really looking at this, what we started with was, again, I'm gonna say it one more time, was there is no justification, and we have a contract. We have a contract in place that needs to be honored, and that contract should be honored until the end of this 5-year period. That's what we started with, and today we get exactly what we wanted with options 1 and 2, and we get in the city honoring that contract and us doing the same. Thank you, Mr. Chair.
Thank you, Commissioner Maddox. Commissioner Minor.
Thank you, Mr. Chairman. Commissioner Maddox, very, very good comments. Thank you. First of all, I've got some good news. If you've been paying attention to what we've been saying on the dais here, I think it's pretty clear that this county commission will be voting to keep our fire service fees the same for the next year. That's the good news. No increase. But as we've all talked about, the question still remains about option 3. Should we proceed to continue with our dispute resolution process? Commissioners Maddox, Cummings, Welch, I think are striking the perfect tone here. You know, for 37 years, the city and the county have had an agreement on fire service, and it hasn't been perfect, but residents within the entire county and the city have benefited by having fire protection. This community works best when the county and city work together in good faith to serve the people who live here. But at the same time, we have to take a look at what our obligation is for option number 3. And so I have a question for the county attorney. You know, Commissioner Maddox had talked about what the impact might be should we have option 3 passed and we go through that analysis of the items you've identified, the 3 items here, and possibly others. how would that work? If we did pass option 3, the dispute resolution process would continue. You and your staff would hire the financial consultant. You would work with the city on these 3 items and possibly other items, and you identified savings. How would those savings be applied, if at all, to ratepayers?
I think that is an open question. Certainly for the debt that was issued without the authority of the county and any other expenditures that were done in that manner, the argument would be that wasn't included in the rates, that wasn't authorized, that was a breach of the agreement, it was inconsistent with the rate study, and the city needs to pay for that from other sources. If you're talking about they imposed the wrong rates, I think they would have options. Could they go back and try to claw that back from their utility customers? They could, although I think that would probably be an administrative nightmare for them, but they could do it. I don't know. That would be up to them, whether to true that up from another source or whether to go back and capture that from constituents who didn't pay the full rate. If you're talking about the issue, if they haven't already trued up, that would have to come from another source because that's what they're obligated to do under their resolution. They would not be able to go back and pass that on to other constituents. And they made a determination it wouldn't be cost effective for them to try to go back to those properties and collect that money that was underfunded. So they would have to use some other source for that. That would not be something that the constituents would pay through the rates.
So to me, this is the key question, right? This is the key question on whether or not we support option 3 or not, is what benefit is there to county ratepayers by passing option 3? And Madam County Attorney, it sounds like it's an open-ended question, but that the chances of our ratepayers benefiting by going through the dispute resolution process is good. In other words, we're looking at how the fire service fee has been applied. We're taking a look at following the interlocal agreement and making sure that on both counts, those are done fairly and uniformly, correct? So could we assume the chances are good that Leon County ratepayers would benefit by going through the dispute resolution process and looking at these items more closely?
To the extent the city would have to pay those things out of other funds, then the people who pay the rates would not be impacted adversely by that. I think that there's the chance that at least for some of those, that would be the case.
Okay. Sorry, Commissioner Maddox, go ahead.
Commissioner Maddox, you want to add something?
No, I was just wondering, you said that they would benefit. They would be held harmless. They wouldn't benefit per se, they just would be held harmless, correct?
They would benefit to the extent that monies that should have been in the Fire Services Fund or in the Fire Services Reserve Fund were actually recouped.
Okay. So the answer is yes. The potential is yes. Right?
The potential is yes.
Yeah, okay. To me, that's the key question. And like Commissioners Maddox and Cummings and Welch have said very well, I have no animosity to the city. This is not a way to strike back or anything like that. I'm looking at this from a very dispassionate point of view, which is how we need to look at it. We work with the city. We need to continue to work with the city. And in 2028, we need to work with them on whatever the next agreement's going to be for fire services. So I recognize all that, and I know for our folks who might be watching on the city side, I don't think anyone here has animosity toward the city. I hope not, because we need to work with you, and we need to work well with you. When we work together, our citizens and the entire community benefit, and we need to maintain that. So I'm going to support option 3 because I do think that the county commission has an obligation to look at these more closely. It's not anything other than that. I think that because we have the interlocal agreement, even though these are city functions, we have an obligation and a responsibility, in my opinion. I respect those who might disagree with me, but for me, this is an idea of making sure that ratepayers are being treated fairly and that the interlocal agreement is being followed entirely. So I'm going to support the substitute motion for options 1, 2, and 3. Thank you, Mr. Chairman.
Thank you, Commissioner Minor. Commissioner O'Keefe.
Thank you, Mr. Chair. I got a couple questions and then comments. So my questions is focused around our volunteer firefighter departments. So we have volunteer firefighter departments across the county, mostly serving unincorporated areas, and these are staffed or volunteered by citizen volunteers who, for free, volunteer to be fire service first responders for those communities. They get some funding from the county and out of the fire service fee, and they also seek other donations, but I don't know how much that really contributes to it. So keeping in any of this discussion, is the amount that is budgeted for county volunteer firefighter departments going up or down?
No.
Okay. And we know that our agreement with the city, we've been talking about the official paid city fire department. Neither county or city without joint approval can increase fire service fee rates. Does that not allow us to, if we chose to independently increase funding for volunteer fire departments, are we still allowed to do that?
Not if it affects the rate.
We would have to do it out of a general fund or something. It couldn't be paid
Right.
by fire service fee.
Right.
But we are okay at the current amount we are giving them out of the fire service fee.
We are.
Okay. And maybe it won't go to Ken, maybe it'll be Vince. Do you know how much that total is each year for all the county money to the volunteer fire departments?
A little under 500,000.
A little under $500,000. Okay. What I would just like to plant a seed here is that as we go forward in future years, I think that if after validation and verification and agreement, if we find that the cost of fighting fires by the fire department is actually going up, I think it's important we remember to come back and consider, is the cost of volunteer departments fighting fires going up? And that we remember that they still need to be funded to operate in those unincorporated areas, especially that those folks are volunteering for that service for their community. Back to I just don't want us to forget that. It may be a small amount in a large budget item, but it is no small impact to the people volunteering and to the people who get responded to by those volunteers. So back to the main issue here, there is no winner and loser in this discussion. This is not a competition. This is a dispute between two parties who are partners in an agreement of one of many serving our community. We aren't successful going alone without the city, and the city isn't successful going alone without us. These are our partners. Now, I may not be super familiar with the movie Dirty Dancing, but I understand the concept of partners. So, let's go back to where we really started here. We got here when we were notified by our partner that the fire service fund fee, the facts that they gave us were it will run out of money if there's not more money going into it. And we haven't heard any change in that fact from them. What we have learned is that we cannot be forced to increase what we charge customers, and if they cannot increase what they charge customers unless we agree. That is good news. And to reiterate Commissioner Minor's point, no matter which motion we vote on today, the county is going to vote today to send notices next week that we will not be increasing fire service fees for our citizens, period. Now, if the fact stands that the fire service fee fund will not have enough money to operate, we have to find out how that is. If it's not because the fees aren't enough, if it's because unauthorized expenses have gone out, or both parties, one or the other, haven't put enough money they're supposed to in, that's the point of option number 3, is to address the fact that we have been told by our partners that there's not enough money in the fund. We've addressed the fact that we can't be forced to raise the fee, but we still have to address the fact that there needs to be money to fund a fire service and a fire department, and we want to find out why it's not enough and go from there. Since we're doing quotes, a former president said, "Trust but verify." That is why we are doing option 3. Thank you.
Thank you, Commissioner O'Keefe. Commissioner Caban, Mr. Vice Chair.
Thank you, Mr. Chair. Commissioner O'Keefe, that was very, very well stated. Very well stated. Trying to get my laptop up. There it is. Commissioners, it looks like option 3 is going to carry forward. And so I just want to be very brief and close with this. This isn't about winning. To me, this is about transparency and what's right. Sometimes when you open a door, you see something you didn't expect to see. And in this case, we didn't choose to open the door. The city chose to open the door by turning down our collegial attempt at meeting them in the middle. Throughout the process, our staff did their homework, and they did a damn good job. Yep. And we saw some stuff that we didn't know was going on. And so this isn't about us being adversarial. It's about digging deeper because I think we owe it to taxpayers. What just happened, or attempted to happen, was the city tried to impose a 22% on residents in Leon County and in the city of Tallahassee. Meanwhile, they're underfunded the account. They're spending money they weren't supposed to. They're not truing up on assessments that they are not collecting. It says that in the resolution and it says that in our agreement. And to be clear, I support a financial consultant looking through our books because I think we also owe it to taxpayers. If Leon County is not doing their job and our job, I think we should true up. It's only fair. And right now, before we go ever asking taxpayers to pay anything, we need to do our homework. And so I appreciate the sentiment of our colleagues, and I'm looking forward to seeing what a financial consultant comes up with and shining more light on this issue. And I think that is the true and honest way to put this issue to bed. Thank you, Mr. Chair.
Thank you, Mr. Vice Chair. County Administrator has some clarity, I think, and then you can speak on point.
Just one quick thing. Again, the board's put due emphasis on the, this issue on option 3, all of which, we take no issue with. And there absolutely could be costs there that we need to true up, all of which has been stated. But it's kind of the smaller issue. The bigger issue, again, just to be very clear, those paying attention, are the added costs that the city incurred, the added costs of ISO,
Right.
big costs, the added cost of labor, the big cost, the added cost of the refining. We've articulated this in the past. Those are the big costs. These are very important too, but I just wanted to make sure I put that in context. Thank you.
Thank you, Mr. Administrator. On point, Commissioner Maddox, then we're going to go to Commissioner Cummings and Commissioner Proctor.
Thank you. I think, Madam Attorney, it's an issue of timing for me. I'm not saying I disagree with option 3 totally. What I'm saying is that option 3 will happen eventually, regardless. Whether it happens now or it happens when we renegotiate, it's going to happen. Madam Attorney, if we go with option 3, how will it play out in the way it's addressed, in the timing of when it's addressed?
I'm going to give you an answer, and if it's not responsive to your question, please restate your question. If the board does not move forward on option 3, we will completely dismiss the arbitration. We will not look into the issues that have been raised any further. Staff will not do anything else until further directed by the board at some time in the future.
Right. So you stop there. So what you're saying is we could do option 3 now, or we could do option 3 to look at these things when we're going through the renegotiation in 28, or no?
The board has that discretion at any time, as long as you're still in this third term and you still have a valid interlocal agreement. That's correct.
Timing, Mr. Chair, the timing of, if we did option 3 now, Madam Attorney, the timing long-term of when, let's say the consultant comes back, consultant tells us whatever the numbers are, what would be the timing of when the consultant will come back?
Well, that's going to depend on a couple of things. We're going to have to request certain documentation from the city. It will just depend on how cooperative the city is in producing those records. If we have questions about what is in those records, it will depend on how cooperative they are in providing answers to those questions. And it really depends on how far in the dispute resolution process we would have to go. The initial review by the consultant would take a while. I mean, so we would not be looking at proceeding to any mediation, certainly any mediation, let alone a formal arbitration proceeding for quite some time. And that's very different from what we were looking at initially, because we thought we were under the gun for a potential rate increase in fiscal year 2026. We don't have that time constraint issue anymore.
So, again, looking at this just timing-wise, if, let's say, again, this is something that we will have, if we were going to address it, we could address it now, we could address it later. If we were addressing it in preparation for our renegotiation in 28, we could also do it that way and still accomplish the same thing? I mean, we've uncovered the issue, and we have a right within our contract to bring these things up. Is that correct?
Yes, you would want to give yourself plenty of lead time. Now, keep in mind, if they were to trigger the termination provision, they'd have to do that no later than early 2027. Any renegotiation of this agreement, I would anticipate, will take quite some time as well. It's not something that's going to happen in a month or two. And if you have outstanding issues associated with any issues, again, I would give yourself plenty of time to get those fully and adequately addressed before you were to enter into any renegotiated agreement.
What happens while we're figuring all this out, if we go with option 3? It just remains, things just remain
Status quo.
as is?
In terms of rates. That's correct.
Thank you, Mr. Chair.
All right, Commissioner Cummings, then Commissioner Proctor, and then we'll go to a vote.
Thank you, Mr. Chair. I don't want to, I guess, beat a dead horse or prolong it, but just a couple of follow-up questions, Mr. Chair. As far as the dispute resolution process and option 3, Madam Chair, and you all have done your research and you have found and basically told us that in order to increase the rate, it has to be an agreement with both parties. Okay. So by that same token, in adopting option 3 and going through analysis and asking for documents and what have you, can the fees be reduced without an agreement from both parties? In other words, can the arbitrators look at it?
No.
And reduce?
No.
So what's good at the top as far as increasing, the same thing at the bottom, the rates cannot be reduced. So it doesn't matter if we go forward with 3, doesn't matter what we find, underfunding, failing to supplement from non-fire services sources, overinflated rate for Fire Station 1715. Rates can't be reduced unless both parties agree.
That's correct.
Okay. All right, and then my other question is, proceeding with option 3 in this process, could the policies of the city be changed as it relates to, I mean, we've talked about exemptions for churches. There have been some concerns about whether or not it's fairly applied to all interested parties. Could this dispute resolution process address that or change the city's policies without, I guess, agreement of the city? Mr. Chair, can she answer?
Yes, go, you can speak freely.
So And Commissioner Proctor touched on this a little bit before. So property of religious institutions is accessible, okay? It's not like under our current methodology where vacant land and agricultural land are not accessible, okay? So to the extent the city were to modify its policy or change how it applies it, we need to do so uniformly. It could supplement that and make up whatever assessments it's not collecting from that exempt but otherwise accessible property from its own other revenue sources. The county could do the same. But it all depends on, but the reality doesn't change that that property is accessible. And whether it's in the city or the county, someone other than other ratepayers has to pay for that benefit that's received by those properties.
Madam County Attorney, do you anticipate if we go forward with the dispute resolution that that will be one of the issues that will be raised by your office with the city?
I think it would be very hard to arbitrate that particular issue, and I'll tell you why. Because even if an exemption is provided for, it only covers certain property of a religious institution under the statute. So there's a case, for example, that says administrative, properties used for administrative purposes don't qualify as places of worship, okay? So when an exemption is being applied, it's going to be a case-by-case determination because, you know, you've seen the tiny cinder block church where really it's just a sanctuary and that's all there is. Well, they would get a full exemption for that if an exemption is in place for places of worship for religious institutions. Now, you have different churches that perform other functions, that have other amenities and things like that. Would that qualify for that exemption? That's always determined on a case-by-case basis, and with the number of churches you have in the incorporated and unincorporated areas, I think it would be really hard to collectively try to arbitrate every specific instance related to that type of an exemption. Does that make sense?
It does.
Okay.
It does, thank you. So bottom line is moving forward with the dispute resolution process at this time might uncover some issues that between the city and the county that I guess could be subjects of compromise or what have you, but it won't affect the rate that our citizens are paying unless the two parties agree, number one. And number two, hopefully we are bound by the contract that we have now with the city throughout the duration of the 5 years. And if the parties agree to the 2 one-year extensions, it could be throughout 2 extra. So I guess my bottom line question is, what do we want to accomplish, commissioners, with option 3 if it's not going to benefit our citizens, if it's not going to benefit the taxpayers? And if there's an agreement with the parties at the end of this contractual period to enter into another agreement, I think prior to that, I believe the parties will agree like they did before to have a study done of the actual costs for fire services, fees, and the actual, personnel costs, the whole list that we have in our information today. I think it would be prudent for both parties to have that done, and then we would have more accurate costs. And that way, I would feel better with the assessment that we would agree to for our county constituents. But otherwise, it just appears to be exercising futility, in my opinion, with staff time. The county administrator already indicated it's going to cost. The county coffers, which I understand from an administrative standpoint, but I like to take steps that's going to benefit our constituents. And I think, like Commissioner Maddox indicated, that maybe this would be more beneficial a couple of years down the road, all right? Close to time when we would either negotiate with the city or extend this contract. But at this point, it just appears to me that it would be an exercise, just an exercise in futility, and that's it. Thank you, Mr. Chair.
Thank you, Commissioner Cummings. Commissioner Proctor, and then Commissioner Maddox is after that.
Thank you, Mr. Chair. This has just been a wonderful day, and I'm appreciative for you all allowing me to be a part of your wonderful day. I'll recap your beautiful letter. Mr. Chairman, and you indicated that collective bargain agreement was a factor, Leon County Schools was a factor. I still don't know why, if the Leon County Schools ain't paying what they supposed to pay, why we would levy a 22% increase. That need to be duked out by the city and school board, not just given to us silently to say, well, we'll let them go, shrug our shoulders, and no, the county, if they dumb enough to do it, let them do, we'll recover. It's crazy. We can't pay everybody who don't pay their bills, okay? I appreciate the letter you sent. I appreciate its tone, Mr. Chairman. But I also look and am disappointed with Mayor Daley's response in saying that the level of service and response he wanted to increase. He did not answer what the chairman sent him. And evasive, didn't talk about the ISO rating increase, higher ISO rating could lead to a reduced property insurance rates for residents and businesses. Our county attorney says it ain't got no relation to nothing. And y'all seen a wet mullet flip-flopping on the ground. And then the city, in conclusion, cannot guarantee that adjustments for unanticipated changes in costs will not be recovered. So we're told to swallow this after 18 months, but we can't guarantee that we're gonna come and do it again. Really? Okay, so I'm comfortable with option 3, but there were 3 bombs dropped on page 8, which I didn't get a chance to indicate. The county staff has concluded that the city did not impose the correct fire rescue services rates in 23-24 and 24-25. That's probably how we got here, because of malfeasance or incompetence. The city ain't done their job, and our staff said that it was required in the 3rd term rate study. But let us not be dissuaded from our intuition and our instincts. There is no third-party consultant. That's a shell, because the city gives the third-party consultant its own numbers. The consultant is just getting a check and can't validate or verify their numbers are authentic. It's just their name signed to a sheet of paper. I'm glad we're smarter than that. Our staff tells us that the flat rate has been negated. It's been inconsistent. staff told us. I was impressed by the next, or rather depressed by the next area, that City Resolution 23R19, Article 3, some more words. The provision obligates the city to supplement the fire services budget from sources other than the fire service assessments with amounts necessary to provide fire services, facilities, and programs to such property. So why is, if they are required through their own resolution, what is they down here in our face for? Okay? Policy tells them what to do. They just don't want to follow. And it's that spirit of being intractably indifferent, aloof, haughty. They got directions on what to do. And they're acting like our staff would not read. Our staff has asked for, county staff has requested confirmation from city staff whether in fact the city has complied with its obligations to true up monies that it has not collected on property with structures that are unoccupied or where utility services have been. As of the publication, this publication of this agenda, the city has not provided a response or any supporting documentation. And if we can't get a response and we're a partner in an agreement, I mean, if your wife can't get a response out the husband and he's in the marriage agreement, I mean, ain't no other woman gonna get no response. I mean, they are a partner and we can't in good faith get a response. How can a citizen, how can them people's church find out what's going on and why they don't have a waiver? We can't get it. And then the last bomb here is that we're told county staff has confirmed that the city has already incurred costs that were not included in the third term rate. Really? What they talking about? As the board is aware, the current rates include $17 million to construct Fire Station 17 without obtaining the approval of the AMC, which is Vince and Reese, notification to or approval by the county, or the development of a new rate study to incorporate the additional costs and to increase rates. In 2024, the city issued debt in the amount of $27 million for the construction of Fire Station 17, which is $10 million more than was contemplated in the rate study. Ladies and gentlemen, I will pull up from there. I've read enough alarms are going off. Our staff is trying to get our attention. We're a party to and partners with folk who are not acting in good faith. And there was no contemplation that debt would be issued, and that debt has already begun to be serviced from monies collected from the fire service. I've asked numerous times, where does the $11 million that we collect from county residents for the fire fund for the city, where does it go? I don't know. We don't know. But we collect 11.4 million, and the city transfers 11.7 million from the fire fund fees to the general fund. That means 100% of the money we take up, it goes to undergird city services, which makes this taxation without representation, because these people paying this tax, this rate, this assessment, this fee, whatever the word is, they don't get to vote on the people who are going up on their fee, their rate, their assessment. So we're doing the right thing today, because the people who are paying and being asked to pay 22% more still won't be able to vote for the people who are charging them public money. And so I'm delighted today that we have more than a lapdog county attorney. And I have no interest in going to lunch, dinner, being friends with nobody at the city commission. That's not what I'm here for. and I'm not interested in going to lunch or dinner with either of you, either. My concern is that I represent citizens, and as Commissioner and Mayor Dodd has indicated, this is regressive. And when it's a regressive alignment against citizens of this community, I get it hit the hardest if it's regressive, because I've got the poorest citizen. And something like this, it hits us very hard. So I'm really happy today for the citizens, for this issue, for our staff having a backbone and helping all of us to understand. And I would like to say to them, continue to be diligent to represent the interests of even those of us who are already paying the taxes to the city for utilities. We can't even get sewer pipes to relieve our yards of what we have to place in them. These things and other things like the utilities, I hope that in the, what's that word? The citizen group that we're bringing together to look at the charter review, what needs to occur is that the county needs to take over utilities, period. And the city is operating without a citizens utility review board. And I don't know why people are paying for utilities and can't get equal service, equal protection for having sewer pipes. And we got two different health standards abiding in this community. And when you start talking about the utility, all of it is separate and unequal. And the services are gerrymandered, and people are excluded out and carved out of the city so that they won't vote to protect themselves against.
Commissioner Proctor, could you, I hate to interrupt you, but could you wrap it up? I got to go to the school board meeting and present some proclamations real soon.
I yield, sir, I'm sorry.
Thank you, Commissioner Proctor. Commissioner Maddox, you guys still in the queue.
Yes, sir, Mr. Chair, I'll be quick.
Can you close out?
Yeah, thank you. I appreciate Commissioner Meyer's argument. We came back around some of the things that were talked about. I appreciate the focus, as you say, the benefit to our constituents. I think I've convinced myself to go option 3. But it's an issue more of the renegotiation. We need to be in the right place for the renegotiation. And that's not about the current fee, it's about the renegotiation. And when you talked about the timing, I thought maybe we may be able to do this a little bit later. But County Attorney, you said that we're going to need some time with this. I would almost like for this to indicate our interest in negotiating in 28 more so than looking at the issues that we found as a result of this rate increase that we're talking about now. So to make it make sense, what's the timing that we would need to start having our financial consultant look at it so that we can be in the right posture to bring these things up in 28 to be able to, where we're talking about what the new contract looks like in negotiations and what the rate should be, taking into consideration these issues that we're talking about in option number 3. Madam Attorney.
I can't give you a definitive time frame only because I had not received board direction yet. I have not talked with the financial consultant about scope and what her other, obligations are. I mean, we won't be the only entity she's doing work for. Also, there are other factors. The city is going to have to provide documentation. They're going to have to answer questions. All of that is kind of outside of the control of us or a consultant. But I can guarantee you it will take months to do that work.
Commissioner O'Keefe, it's semantics, but I like it. If for option 3, we could rephrase it to go for moving on this exploratory, to hire a financial consultant to look at where spending may have, where we're underfunded or where underfunded or where monies were spent that will put us in posture to be at the right rates in the correct, funding sources for our 28 negotiation.
Commissioner, I can't do that because
Fair.
what number 3 does is
It's okay.
verifies
You
the...
don't have to explain it. It's
No,
okay.
but I get to, though.
Chairman, you going to the school
He
board?
got to go to
Yeah,
the school board, so
We
Commissioner
already would have
Maddox,
finished what I said.
Let him.
I thought he had to go to
let him
school board
explain.
and cut me off.
I can't do that because what number 3 does is ask to verify the agreement we are in is being followed. I see no sense in waiting until the agreement's over to see if the agrement's being followed.
it's not waiting until it's over. It will still happen.
All right, Commissioners, we got
Let's
to.
go to the
It's
school.
okay. I'll
vote.
support it. It's okay.
All right, so we've got a motion, I think it's from Commissioner O'Keefe, seconded by Commissioner Caban, for options 1, 2, and 3, staff recommendation. All those in favor signify by saying aye.
Aye.
Aye. All opposed? Okay.
Aye.
So 2 passes 5-2, 2 in opposition, Commissioner Cummings and Commissioner Maddox. Thank you, Commissioners. I think that was a nice, robust conversation. I appreciate the respect, and I'll see you guys here in a month.
Just want to thank everybody for the creative metaphors to tonight's meeting.
A lot of metaphors.
Johnny and baby and
I'll ask you.
puppies and all that.
Okay. All right, with that, we are adjourned. Thank you.
Hey, Brian, can you...